Are you dealing with an estate in Georgia and feeling overwhelmed by the probate process? Today, I'm going to simplify it for you and even share how living trust can help you avoid this complex procedure. Hi, I'm estate planning attorney Mike Smith with Smith Barid LLC, and I'm one half of the Estate Planning Guys. In this video, we're going to explore the probate process, uncover some steps to simplify proceedings, and reveal how a living trust can be a game changer. The probate process in Georgia can seem complex, but it's a crucial step in administering a deceased person's estate. So let's break down what's called the probate in solemn form process, starting with the filing requirements. So the first thing that you're going to want to do if you need to file a probate is, in my opinion, contact an attorney. You can do it yourself. It can be pretty complicated, and so it's best to have that professional guidance. So I would suggest contacting an attorney to help you with the probate process. And then the executor or another interested party will file the petition with the county's probate court where the decedent lived. We call the deceased person the decedent. So where they lived at the time that they died. And if you've hired an attorney to help, the attorney will do it for you. If not, then you'll have to prepare that petition yourself. You also need to have the original last will and testament. If it exists, it's essential. If the will has been misplaced or lost, there are ways to probate a copy of the will, but it becomes a lot more complex if you're needing to probate a copy of the will. So the original will is really essential to this process going smoothly. It's a requirement if the original will exists that it be filed in with the petition. But like I said, if the will cannot be located, there are ways to go ahead and probate the estate. Probate the will without the original will. It's just much more complicated to do that. There's a filing fee that the court is going to charge for the filing of the probate petition, and that varies by county. So if you have an attorney helping you, the attorney will contact the court and determine what the filing fee is. If you're filing it yourself, you're going to need to talk to the court clerk and figure out exactly how much the filing fee is for the petition that you're going to be filing in. Now, once you've got the petition ready to file, there are some notice requirements. With a petition in solemn form, if you do the notice part before you file it and you get the beneficiaries and heirs to sign an acknowledgement saying that they consent to the probate, that's a much faster way to do it. But if you're unable to get that acknowledgement and receipt signed, then you still have to notify all of the heirs. So these are any person that would have been entitled to some portion of the estate if the decedent had died without a will. And then you also have to notify what are called the beneficiaries. So the beneficiaries are the people who are named in the will to receive some sort of distribution from the estate. So we've got heirs who have to be notified, and we have beneficiaries who have to be notified. And that is a requirement under Georgia law. The purpose of that is so that there's transparency in the process and everybody involved is aware of what's going on. If you are unable to locate some of these people, either heirs or beneficiaries, there is a way to serve them by publication by running a notice in the county's legal organ. It used to be a newspaper, now it's online, but there's a way to run a notice in the paper and serve them by publication if you're unable to locate them. If they will sign the acknowledgement and receipt, then you're done in terms of service and notice. But if they won't sign that, then you may have to have them served. And there are different requirements in terms of service, depending on where they're located, either in-state or out-of-state. It could be that you have to hire a process server to serve them. You may be able to serve them by certified mail. They're just different requirements depending on whether they live in-state or out-of-state. So you have to research that if you're doing it yourself, or your attorney will handle that for you if you have an attorney to help you with that. So if you're interested in learning more about how we help families protect their legacies from probate, predators, and government intrusions, I wrote a free book titled The Ultimate Gift that lays it all out. If you'd like to pick up your free copy of The Ultimate Gift, simply click the link below, give us your address and a credit card for shipping and handling fees, and we'll ship it out to you free of charge. Read The Ultimate Gift so you can learn how to protect your family. Now, the heirs do have, so if we are unable to get the acknowledgments and receipts and we have to serve the heirs, they do have a period to object to the probate. They usually have 10 days after notice to notify the court that they are objecting to the probate, and the court then would schedule a hearing in case of any objections. It can, if they file what's called a caveat, which is a formal objection to the will, potentially saying the will's invalid, or that there's some other problem with the technical aspects of it. In that sort of case, then there could be a full trial in probate court. It could go that far. So once this is all filed in, then the court will review the petition, make sure it's all correct, and then they will set down a hearing to have the executor sworn in. Now, it's a hearing, but there's nothing that happens other than the executor, raises their hand and swears an oath to faithfully fulfill the duties of an executor, and they're given some information by the court about what's required, etc. So it's a pretty simple process. The actual swearing in, typically the attorneys don't go to court for that. It's often done online now. And it's a really routine sort of 5 or 10 minute hearing with a clerk or a judge where you're just swearing that you'll faithfully fulfill the duties of the executor and then signing the oath. Once that is taken care of, then the court issues an order called letters testamentary. And this order is what authorizes the executor to act on behalf of the estate. So once those letters testamentary are issued, then the executor can take action on behalf of the estate. Before that, no one has any legal authority over the estate. And that can lead to problems if sometimes there's a hang up in getting someone appointed and there are, for example, mortgage payments due on the house, or there are bills that need to be paid, like the power needs to be kept on at a house to make sure that things are maintained properly. Somebody's got to come out of pocket for that during that interim until the executor is appointed. So that can be an issue at times. But once the executor is appointed, there are some requirements that they have to fulfill post-appointment. The first one is that they have to file an inventory and appraisement. So an inventory just sets out what all the assets are in the estate, and then an appraisement assigns some sort of estimated value to those assets. If a will is drafted with a waiver of that requirement, which in my opinion, most attorneys in Georgia, if they do estate planning on a regular basis, would waive those requirements. If those requirements are waived, then the executor doesn't have to file an inventory and appraisement. But if that's not in the will, then they will. The executor may also have to obtain a bond. That again is a requirement which can be waived in the will if it's properly drafted. But if it's not in the will, then the executor will have to post a bond, which is basically an insurance policy that will pay the beneficiaries and heirs if the executor runs off with the money. You can also file a separate petition asking the court to waive the requirement of inventory and bond. All the interested parties will have to sign off on that. But when you get the acknowledgement and consent for the probate, sometimes if we need to file that, that's the same time we would get the consent to the waiver of those requirements. The third requirement that the executor has post-appointment is to file reports with the court. So there are annual management reports that have to be filed, returns that have to be filed with the probate court. And again, this is a requirement which can be waived in a properly drafted Georgia will. If it's not in the will, though, then the executor will have to fulfill this requirement. If it's not in the will and we don't file a separate petition asking the court to waive that requirement, then the executor will have to fulfill the requirement of filing annual reports with the court. Now, once the executor is appointed, at that point, there's another notice that has to run. This is called the notice to debtors and creditors. And this is a notice that just kind of puts the world on notice that the estate has been opened, and anyone who owed money to the decedent is asked to come forth and file a claim advising the executor of that obligation. Likewise, if the executor owed money to someone else, a creditor, this is their opportunity to file a claim, to come forward and say, hey, Mr. Jones owed me some money when he died, and here's how much it is. Once that notice period expires, creditors have 3 months to file any claims after that. And at that point, the executor can distribute the assets out of the estate. And we typically will prepare a waiver and a disbursement sheet for any beneficiary or heir to sign off saying that they're not going to bring any kind of claim against the executor and that they've received everything they should have from the estate. And at this point, the probate is essentially, once all the assets are distributed, the probate is essentially over. In some cases, we may encourage the executor to file a final accounting and receive a discharge. It's not a requirement under Georgia law, but if there's been any kind of issues, that discharge and final accounting will give the executor a release from any personal liability for the job they did as executor. So if we are concerned that somebody may come forward and raise a claim, we would encourage the executor to go forward with seeking a discharge. And that process is very similar to opening the estate. You have to file a petition in, there's some notice periods, and then once that's satisfied, then the court can issue a discharge to the executor. Remember, probate is kind of complicated. And so it's best to consult with an experienced attorney who does a lot of probate work because there are some nuances and there are some fine details that need to be taken care of. So here are some things that you can do to simplify the process a bit. The first one is have all of the necessary documents ready. So what are the necessary documents? Well, we've mentioned a couple of things. The first is you need the original will. A copy of a death certificate is good for the attorney to have. It's not a requirement that it's filed with the will, but a copy for the attorney to reference is a good idea. Any information about assets, so bank statements, insurance policies, any kind of statements for investment accounts, deeds for real property, all of that information is relevant and necessary in the probate process. And so gathering all that together at the front end and having it very organized is extremely helpful, whether you're representing yourself or you're working with an attorney. The next thing is communicate clearly. It's important that you communicate with all parties who are involved. I've seen many times where probates will kind of go sideways because the executor feels like they don't, under the law, they don't necessarily have an obligation to, communicate very much with the beneficiaries or heirs. However, I think it's a really good idea to sort of over communicate about everything that you're doing. That really reduces the chances that somebody sitting on the sidelines is going to be, looking over your shoulder and saying, "Oh, you didn't do this right. You didn't do that right." So communicating clearly with everybody involved is super important to making sure you have a smooth probate process. And then the last thing, I can't say it enough, to really move things along and make it a smoother process for you, an attorney is a great person to add to your team. You can do it yourself, but the help of an experienced attorney is really invaluable in these probate proceedings. So let's talk just for a minute about how living trusts can help avoid probate. They're excellent tools for bypassing the probate process, and they save you a lot of time and they reduce stress. I think of the living trust as a bucket into which you put all of your assets, and as long as you're alive and you're competent, you're holding the handle to the bucket. And so if something happens, you can just hand that to someone else. They'll take care of it for you while you're alive. That person's called the trustee. And then when you pass away, the person you've chosen to take over after your death, the successor trustee, just picks up that bucket and they distribute the assets out of the trust. They don't need to go through probate to do that. They have permission as the trustee to make those distributions, to pay any debts that are due, and they don't have to file a probate in order to accomplish that. So a living trust is a great way to avoid the necessity of probate and the complexity that comes along with it. So if you're in need of guidance with probate or setting up a living trust, feel free to reach out to us, the estate planning guys. Visit our website, contact us directly at Smith Barid LLC, and we'll be happy to help you. Remember, effective estate planning today can prevent complications tomorrow. So thanks for joining me, Mike Smith, in this discussion. If you found this information useful, please consider watching our next video for more insights on estate planning. Stay informed and prepared with the estate planning guys. I hope you enjoyed that video. If you did, then take a moment right now to subscribe by clicking below and turn on the bell notification so you get notified every time we post up a new video. Right now we're posting 3 videos a week with lots of information about various estate planning topics, so you're going to want to make sure to stay on top of that. Click below to subscribe and click right over here to watch the next most relevant video about estate planning. Go watch it now.